are here in person, as well as those of you who are participating and here with us virtually. Melody, thank you so much for the kind introduction. As Melody said, my name is Daniel Knight. I'm an attorney here in Raleigh with Parker Poe Adams and Bernstein. Just a little bit more background on me, just so you know kind of where I'm coming from. As Melody said, my practice is predominantly in the area of construction litigation. So what that means is it means I represent construction professionals, a variety of construction professionals. So owners and developers, I represent general contractors, and then I represent architects and engineers and even some land surveyors in a variety of construction-based disputes, okay? And so those are going to be things like, whether it's just a simple payment dispute, like a mechanics lien claim, construction defect claims, design defect claims, payment and performance bonds, anything like that, just kind of a variety of construction disputes. Those are the kinds of things that I represent clients with. My experience is pretty broad ranging. I've had the fortune of being able to represent clients on a variety of types of construction projects. So everything from single family and multifamily residential jobs to commercial, mixed use, retail, healthcare facilities, government buildings, and some education facilities. So pretty broad range of experience. Been practicing since 2014, but I've been with Parker Poe since 2019. Parker Poe is a mid-sized regional firm. So for those of you who don't know who we are, we've got about 270 attorneys, a little over 270 attorneys across 8 offices, located in 3 states, as well as Washington, D.C. And so I, along with 3 other attorneys in our Raleigh office, make up the construction practice group for the Raleigh office. And so for those of you, as you can see, actually, let's see if I can't get the prompt off the screen. So I'm here to talk with you this morning or this afternoon about standard form contracts, okay? And what are they and how do I choose, okay? Hopefully most, if not everybody, is generally familiar with the standard form contract, but we'll talk a little bit about what it is or what they are and how to choose them, okay? So what is a standard form contract, okay? So I'm going to try and avoid this presentation being purely legalese, okay? I'm going to do my best, but I'm a lawyer. Unfortunately, I tend to talk in legalese, and I apologize in advance. But Black's Law Dictionary defines a standard form contract as a, quote, usually pre-printed contract containing set clauses used repeatedly by a business or within a particular industry with only slight additions or modifications to meet the specific situation, okay? Now, standard form contracts can be found in practically every industry, okay? I only practice in the construction industry. That's where my practice centers on, but you can generally find standard form contracts in, purchase and sale agreements for property, lease agreements, car purchase agreements, healthcare industry, music industry, right? Retail industry. Every industry has some form of standard form contract that has been drafted by one or more collections of individuals with knowledge and experience and education in that industry. Okay. And the construction industry is like the rest of those. The construction industry has standard form contracts. Okay. Now, there are a number of different organizations in our industry that have come together and drafted sets of standard form contracts. Okay. And what I've done is I've put together kind of some of the larger players, if you will. This list is in alphabetical order. It's not in any sort of order to indicate popularity or which one is the most widely spread or widely used, which one is the most favored, right? It's just an alphabetical list, okay? But the first one that I think most people in our industry are familiar with is the AIA, and that's the American Institute of Architects. AIA was founded in 1857. It is readily one of the most widely used construction, standard forms in our industry. I see it in my practice. I don't want to say on a daily basis, but on a weekly basis, whether it's reviewing the contract, because some dispute has arisen, or reviewing the contract during the negotiation phase. I see it all the time, right? And there are a number of forms. We'll talk about a couple of those here in a second, but in case you weren't aware of just the scope of forms that are available through the AIA. As of yesterday, and when I say yesterday, I mean last night at 11 o'clock, after I finally got my toddler to go to sleep, AIA publishes over 200 documents, okay? And those documents range from contracts, obviously, right, to exhibits, right? Other ancillary documents that are critical to our industry, like change orders, payment applications, RFIs, ASIs, right? Schedule of values, things like that. You got over 200 documents that have been published by the AIA, okay? Just a little bit of a history about the AIA in case you're not aware, right? So again, AIA was established in 1857 by 13 architects. In 1888, they published their first standard form document, okay? It was called the Uniform Contract. It was co-sponsored with the National Association of Builders, and it was used for about 25 years before they ultimately switched in 1911 and published the first edition of the standard form, or the standard documents, okay? The first edition, I was reading some history about that through a couple of resources, including some treatises that are, popular for construction lawyers. And, generally the first edition was not well received by architects and contractors due to some of the risk shifting provisions. And so that then led to the creation of what is called the Committee of Contracts, okay? And it was a group of individuals that came together to try and jointly draft standard form documents, okay? And since then, the AIA has been publishing and creating and updating its standard form documents, okay? The AIA documents, as I'm sure many of you know, but just in case there are some of you who have not, had the chance to either see or to be a party to an AIA document, but the AIA documents are organized by series, okay? When you look at an AIA document, it's an alphanumerical document, right? So it starts with a letter followed by a series of numbers. And those numbers, the letter and number, tell you what series the document falls within and what the document is, right? So the A series documents, so for example, the A101, the A201, which are probably some of the most commonly used forms, those are the owner contractor documents, okay? So the A101 is the standard form of agreement between an owner and a contractor, and I believe that is the lump sum basis agreement. The A201 is the standard general conditions between an owner and an architect, or excuse me, an owner and a contractor. The B series are generally going to be those documents that are entered into between an owner and an architect, okay? C series, and you just kind of go down the list. C series, these are going to be other types of agreements such as architect consultant agreements. The D series, I label it miscellaneous documents, but as of last night, there's only a single document published under the D series, and that's the D200, which is the 1995 project checklist. Then you finally have your E series, which are generally BIM related as well as sustainable projects. And then finally you have your G series. Anybody who's worked on a job has probably seen the G series payment application. I believe that's G701, G702. Again, these are going to be these are going to be documents related to contract administration as well as project management. So this is where you're also going to find your form change orders, your payment applications, ASIs, RFIs, CCDs, things like that, okay? Some of the more common documents, again, I mentioned the A101, the A201. I was going to go through and just mention just a couple of them by name, just in case any of you are wondering, okay, well, what are some of the other documents I can find within the series, right? So you've got your A101, which, like I said, is your standard form of agreement between the owner and the contractor on a stipulated or also a lump sum basis, okay? A102 is a similar document between the owner and the contractor, but it's on a cost of the work plus fee with a guaranteed maximum price, okay? Your A103 is similar to the 102, except for there is no guaranteed maximum price, all right? The A201 are your general conditions. The A401 is the standard form of agreement between the GC and its sub. Again, getting into the B series is your owner architect document. So the B101 is the standard form of agreement between the owner and the architect. The B102 is the standard form of agreement between an owner and architect, but without a predefined scope of services, okay? B201, again, it's standard form of an architect services, but with design and construction administration included in the services. And then the A401 is the architect consultant agreement, right? So that's going to be where the architect contracts with, a mechanical or electrical or a civil engineer. The next organization, going down the alphabetical list, in terms of the major players on standard form stage, it's going to be the AGC. Okay, this is the Associated General Contractors of America. AGC was established back in 1918. Similar to last night, after I got my toddler down, currently the number of published documents stands at over 100 documents. Like the AIA, these documents include contracts and contract related, right? Payment applications, payment and performance bonds, certificates of substantial completion, and many, many others. Like the AIA, the AGC is also organized by series. Their series is a little bit different. It's a numerical series rather than an alphanumerical series. With the 200 series being your general contracting documents, 300 being your collaborative documents, 400 being design build, 500 is your construction manager at risk, 700 is your subcontracting series, 800 is program management, and then finally 900 is your public-private partnership documents. Okay, triple P. Now I will just tell you, just out of pure candor, I have never had an AGC standard form document in my practice. I've never had it come up. The documents I've typically always been involved with have always been an AIA, or what we'll talk about next, which is the DBIA, Design Build Institute of America. I just haven't seen AGC documents, and in talking with some of my colleagues, they really haven't seen that many of them either. I'm not sure if that's a jurisdictional thing. Maybe they're just not super popular in North Carolina, but they are popular in other states, right? One of the things that AGC has done, and I think probably what I kind of, and some of the construction treatises in North Carolina and in the United States, is one of the things AGC did was they created a standard form subcontract agreement. Okay. It was created in conjunction with the American Subcontractors Association, as well as the American Specialty Contractors. Okay. From that agreement, many of the local AGC organizations have created their own state-specific standard form subcontract agreement. Okay. And you even have some of those state organizations that have created their own state-specific prime contract, right, between the owner and the GC. I was trying to figure out if North Carolina AGC, if the Carolinas AGC has come up with that, and I'll be honest, I was unable to locate anything indicating that we have a state-specific form through the Carolinas AGC here in North Carolina. And in chatting with some of my colleagues, neither of them had come across it or seen it in their past practice either. So today, I don't think North Carolina, the Carolinas AGC has a state specific, but if they do, and you've seen it at some point, I would love for you to reach out to me after the presentation, because I would love to see it. I've never seen, if it does exist, I've never seen it and would love to see it to be able to just know what it looks like. Mentioned earlier, Design Build Institute of America, DBIA. This is, again, another one of the large publishers of standard form documents. DBIA is of the four organizations, so we're on number 3. I've got one more. Of the 4, DBIA is the youngest. Okay, they were established in 1993. They've also got the fewest number of documents because, as you can tell by the name, their focus is on design build projects. Their contracts are not focused on the traditional design bid build method that was used for so many decades, but rather the design build method that's really become popular over the past couple of decades. As of last night, they published over 40 documents. Again, kind of a broad range of documents, from contracts and general conditions to the payment of performance bonds, with, again, the only distinction being that they're focused on a design build basis as opposed to a design bid build. One of the things I did just want to kind of talk about, and again, and part of today's presentation is to talk about, what are standard form contracts and how do you choose? Because admittedly, there are, as you can tell by just doing the math, right, there are so far between 3 organizations, close to 400 documents that are published as standard form documents. And it can be overwhelming for somebody to try and figure out, well, what contract do I need for my specific project, right? And we'll talk a little bit more about how you some things that you should be thinking about when you're looking at your standard form contracts. But just to reiterate how overwhelming it can be and the importance of being careful in your selection, just in the DBIA alone, right? So when you look at some of the offerings they have, right? So they have a standard form of contract for design, build, consultant services. They have a standard form of preliminary agreement between owner and design builder, standard form of agreement between owner and design builder lump sum, standard form of agreement between owner and design builder cost plus fee with an option for a guaranteed maximum price. They also have a standard form of agreement cost plus fee, but without the option for guaranteed maximum price. Okay. And then obviously they then go into the standard form of general conditions. They have a progressive design build, or they have a standard form of agreement for progressive design build projects. And then they even also have a progressive design build agreement specifically for wastewater projects. Okay. I'm not sure if many of you are familiar with a progressive design build basis, or in North Carolina, what we like to call the design build bridging method for public projects. It's one of, in North Carolina and in other states, it's an alternative method of project delivery that is very widely used on wastewater facility projects. Okay, just because of the size and complexity of those projects, it's an alternative method that really works well for those. So again, even with only 40 documents compared to 200 by the AIA, you still have a lot of documents that you've got to try and, you've got to consider, okay, well, which project and, which parties does this contract apply to, and is that right for me, and that's the one that I want to go with. The final organization we'll talk about is the EJCDC, right? So this is the Engineers Joint Contract Documents Committee. Now, if everybody was here in the room, I'd say by show of hands, who here is familiar with the EJCDC? And my hope would be everybody, because Eastern branch of North Carolina of American is the East. So you're one of the chapters of the American Society of Civil Engineers, which happens to be one of the major organizations that comprises the EJCDC, right? So this isn't a standard form document organization that is connected specifically with your parent organization. It was established back in 1975. And I will say, and talking with colleagues as well as just when you go onto the website for this, for EJCDC, these documents are drafted primarily for infrastructure jobs, right? Large scale, horizontal civil jobs, right? These are really what they're best designed for, as opposed to, vertical mixed use 20, 30, 40 step, 40 tower or story tower buildings, right? In addition to ASCE, the EJCDC consists of the American Council of Engineering Companies, as well as the National Society of Professional Engineers. Form documents through the EJCDC, they're developed in subcommittees, okay? The subcommittees are comprised of engineers, but with the advice of attorneys as well, right? Because of the legal implications that come in with contracts. Forms that are developed in the subcommittees are then submitted to the full EJCDC committee for approval, okay? And as of last night, EJCDC published over 130 documents. The EJCDC, similar to the AIA, the AGC, and the DBIA, organizes its documents by series, okay? With the E series generally being your engineering documents, okay? The C series being your construction documents, C series being your construction documents. Within that, I'll include your CM series, which is your contractor, construction manager at risk, right? You have your D series, which is your design build documents, and then you have your P series, which is procurement, okay? And so again, and kind of just to draw a point of comparison, EJCDC documents are similar to the AIA documents in that when you're looking for a standard form contract or standard form document, it's an alphanumerical identifier with the letter signifying the series it falls within and the number being the document specific itself, okay? So if you're looking for an engineering specific document, right, you're going to want to look in the E series for EJCDC, not the P series, right? The P series documents are probably not going to be what you need for, your specific job. So let's talk about how you choose, okay? Unfortunately, there's no secret recipe, there's no secret formula for picking the right document, right? Because again, which document you need depends on a number of different factors, and those factors are constantly changing with each project, right? So for example, who are the parties to the contract, right? So if, since the American Society of Civil Engineers, right? Let's say you're an engineering firm and you're contracting directly with an architect. I would say you probably don't want to be looking at the contract between the owner and the GC, right? The terms that, the scope of responsibilities, the services, even the method of payment are more likely than not going to be applicable. And if you sign a document that doesn't meet the needs of the parties involved or doesn't reflect the parties involved, right, you're going to run a risk of having a situation come up down the road where the parties are in a dispute. You're having to call someone like me, your attorney, and the contract doesn't match what the parties were trying to do, right? And that's going to result in added costs, added time, and added frustration for you all when you're just trying to, you just want to, complete the job, you want to do your services, and, instead you're having to deal with, litigation over, contract interpretation. We also want to consider what type of project is at issue, right? Again, we talked about the Design Build Institute of America. Those documents are predominantly drafted for design build agreements. In fact, I'll be honest, I don't think they have any agreements that are non-design build based documents. I think their documents are all pretty clear that they're meant for design build projects. Well, if your project is not a design build project, don't really want to be looking at a design build contract, right? Because again, it's going to create problems for you down the road when you're having to figure out, okay, well, what was I required to do? When was I required to do it by? What were my obligations under the contract? Other considerations are going to include what services are being performed, right? What are the scope of your services? Or if you're an engineer and you're contracting with a subconsultant, what are your subconsultants? What's the scope of their responsibility? What services are they providing, right? Because again, some contracts are going to be designed with the idea that they're going to apply to a certain set of services as opposed to others. If you're a design professional, you don't want to enter into a construction agreement because you're not actually doing any construction. Okay. Again, reiterate this, but what is the delivery method, right? Is it a design bid build? Is it a design build? Or is it a design build bridging, right? Or is it a public-private partnership job, right? All of those are very important that you got to consider before you select your agreement, okay? Another consideration, how are the services being paid, right? We went through a couple of examples of different standard form documents where they're very clear that one document is for services paid on a lump sum basis. Others are on a cost plus fee with a guaranteed maximum price. I will tell you from my own experience, I've had situations where a party bid a job under one method, and that was the intent, was that they would be paid on the method bid, but contracted for a different method, and then during the course of the job, paid under the method that was bid. Okay, you can imagine the conflict and I don't want to say chaos, but the confusion that kind of ensues when a payment dispute arises between the parties, and one party says, well, you owe me X under method A, and the other party says, well, no, I owe you Y under method B. And now you've got to pay an attorney to figure out, well, which method governs and how much are you ultimately going to get paid on a job, right? So again, what is the method of payment on the job? Now, admittedly, design professionals, this is not as big of a concern. This last one is not as big of a concern as it is for general contractors, right? More often than not, in a lot of the agreements I see for design professionals, architects or engineers, generally, most of the agreements are not delineating between lump sum and, cost plus fee, guaranteed maximum price. Really what they do is they say, we're going to pay you, in accordance with the attached exhibit. A lot of times the exhibit are your staff hourly rates, right? Depending on if you're the supervising engineer, you're an associate engineer, you're an associate architect, and you're going to pay on an hourly basis for the design services. But recognizing that a lot of engineers and a lot of architects undertake projects under a design build method, those terms such as lump sum and cost plus fee and guaranteed maximum price do come in because sometimes those contracts, sometimes they're, they might be poorly drafted. And rather than establishing different payment methods for the different scopes, It's just one because the parties didn't review it, they didn't revise it. And again, now you're being paid, your contract says you're being paid on a lump sum basis when you're thinking you're going to bill on an hourly basis, right? And that's going to be problematic down the road when it comes time for a dispute, okay? Now, let's talk about advantages, okay? Because I'm sure you're wondering, I've talked about, or I've started to gloss a little bit on, the importance of reviewing your contracts. And you got to be wondering, well, why even enter into one of these standard form contracts? It sounds like they're more hassle than they're worth, okay? Well, let's talk about some of the advantages. So one of the advantages is uniformity, okay? And what I mean by that is uniformity of terms and conditions, regardless of the parties or the project involved, right? Again, these standard form contracts, are the result of many people coming together in a collaborative approach to draft a set of documents that are meant to be flexible. And you'll see down the list I have flexibility, right? And so generally speaking, there's this understanding that standard form contracts are uniform in their various terms and conditions, right? Regardless of the parties and projects involved. Familiarity, right? Standard form contracts result in those of us within the construction industry, whether you're a contractor, an architect, or an engineer, or a lawyer, right? Being familiar with the various terms and conditions of those agreements. And that can be an advantage rather than a customized contract that one party, i.e. the non-drafting party, might not be familiar what is meant by a specific term or condition, okay? Certainty, okay? Certainty in contract terms due to a growing body of case law that has interpreted these documents, okay? There, a number of these documents, again, standard form contracts are not perfect, okay? I don't think they're intended to be perfect. They're meant to be a starting point, right? And unfortunately, disputes do arise over the terms within standard form documents. I've had disputes arise over terms within standard form documents. But due to that growing body of case law, and it continues to grow I would say probably every day, but at least every week, a new decision comes out that looks at some standard form document and talks about it, whether it's to say, yes, there's an ambiguity, or no, there's not an ambiguity, and it's clear on its face, right? That growing body of case law can help make a standard form document more certain. If you've used a standard form document, you know that there are costs with the document, right? Either you've got to pay a one-time fee for that document, or maybe you get the document because you've paid for an annual membership. And that is one of the benefits the organization provides to you as a member, right? AIA, EJCDC, I think actually all four make their standard form documents available to their members and only charge a flat-based, like a per usage fee, if you will, to non-members, okay? So for those of you who are already being involved in your respective organization because of all the benefits, right? Then this may seem as a very inexpensive way to get a base contract together, okay? And if you're not if you're not a member of the organization, let's say you're not a member of DBIA, the cost to purchase a DBIA document to then revise it, is going to probably be smaller, more often than not, I'll say, is going to be less than if you pay to have a contract fully customized and crafted from scratch, right? Standard form contracts can sometimes, I say sometimes, emphasize sometimes, expedite the contract negotiation process. Not a guarantee. I've seen and been involved in contract negotiations where the parties had a standard form agreement as their base, and the revisions were as if it was a fully customized. I mean, you would have thought that one party crafted it from scratch because it was marked up and there were red markups on every single page, right? So sometimes it can result in some time savings and expedite your negotiations. Let's be honest, standard form agreements can be convenient, right? Whether you're a small design professional firm and maybe you don't have the staff, to have one person dedicated to your contracts, or let's face it, everybody in our industry is swamped right now. Everybody has way more work, right? And it's a good thing. But what that means is it means things like your contracts can sometimes not get the time and attention that they really need. And so you might not be able to devote the time and attention to craft a fully customized contract. And so a standard form agreement might help with that and is a convenient option. Again, flexibility, right? These documents are, so the organizations like AIA, AGC, DBIA, and EJCDC, they're not, for the most part, drafting these documents on a state-by-state basis. I say for the most part because there are exceptions, right? Like AIA does have, for example, specific documents for South Carolina, and for I think Kentucky is one of them. We talked about how some of the local organizations for AGC have their own standard form agreements. The prime example of that is California. California has its own state-specific standard form subcontract agreement between a GC and a sub, okay? So they're meant to be flexible across, multiple jurisdictions, as opposed to just being drafted just for North Carolina or just for Georgia, okay? But we'll talk about how that can also be a problem in just a second, okay? Another thing that standard form contracts do is they can help eliminate gaps in terms that may not be fully appreciated or recognized when your primary job and your primary focus is dealing with contracts, right? Just like, I'm not an engineer. And so terms that would be readily, recognized by an engineer, I might not fully appreciate, and I might need my client to explain to me why that's important. Vice versa on certain provisions within contracts, okay? And these can help eliminate those gaps. And then the final not the final, but the last advantage that I'll just touch on is this idea that in theory, standard form agreements are equitable, okay? And what I mean is that in theory, they attempt to assign risks and responsibilities to the party that is in the best position to manage those risks or to control them and to protect against the expenses that arise from them, okay? I say in theory because it's not a perfect system. Sometimes revisions are made, either by the parties of the contract or, sometimes one of the organizations will try a revision, find out later on when a case comes down that says, oh no, that here's the result of that provision you put in. And so then the organization goes back to the drawing board and revises it some more, right? So it's equitable in theory, but that's not to say that every single time it is equitable between the parties, okay? And so what I mean by the risk shifting, so for example, generally speaking, what these documents try to do is they try and shift to the owner the risk and responsibility for those unforeseeable and uncontrollable risks, right? For example, weather, right? Weather is unforeseeable and uncontrollable. I wish I could control the weather. I'd make it much warmer than it was this morning, but unfortunately, I have yet to develop that ability. And those are going to fall as an example of an unforeseeable, uncontrollable risk, right? Contractors and design professionals, however, often to the risk and responsibility of foreseeable and controllable risks, right? A design professional has control over its work product, so it can foresee, changes, anything that might impact the quality of its work is going to be responsible for those things, right? That's why there are standard of care provisions in the contracts, and we'll look at some examples here shortly. Some disadvantages of your standard form contracts. First and foremost, one size does not fit all, okay? What do I mean by this? Well, one, no organization yet has come up with a single document that applies to every single situation. And as we've been talking about so far today, you can understand why. It's impossible to have one document that fits every possible party, every possible project, every possible circumstance, right? At the same time, none of the organizations have come up with an exhaustive list of contracts that apply to every situation and every project, right? It's like the insurance industry. The insurance industry utilizes standard form documents, okay? The policies and endorsements are oftentimes written by third parties. For example, the ISP, which if I remember correctly, is like the Insurance Society Professionals. I'm blanking on what the acronym stands for, but they draft a lot of the standard form insurance policies and endorsements, and they have thousands. but it is by no means an exhaustive list of policies and endorsements that apply. And so you will occasionally see custom form endorsements that modify the terms of your policy that are not a standard form document. Okay. So the disadvantage is, again, one size does not fit all when it comes to these contracts. Was there a question? I'm not sure if there's a question. Yeah, I'm assuming there's no question, but if there is a question, feel free to chime. If you're on the call, feel free to chime in or put in the, I guess, the chat function if there is, and Melody can let me know that there's a question. If you're in the room, feel free to interrupt, raise your hand, whatever you're comfortable with, and ask questions. Another potential disadvantage, and I really want to emphasize potential, okay, is the potential for bias, okay. All of these organizations, are very upfront that their goal is to create a fair and equitable document, right, across the parties. And I don't mean bias in the sense of, favoring one person or the other. But let's take an example. Under your AIA documents, a lot of the documents, a lot of times provide way more expanded responsibility for the architect on the job than you might find under the AGC documents, okay? And so that's what I mean by the potential bias, is that, these documents are based on the experiences of those people who came together to create them, right? And everybody's experiences, my experience is different from everybody's experiences here in this room, and that's how it was when these documents were created. So there is the potential for some bias, and so again, it's important that you review your contracts to know what the contracts say and that you understand what they say. On the downside of their flexibility is that they're not state specific, okay? And we'll look at some very specific examples of provisions that are in standard form contracts that are not consistent with North Carolina state requirements, okay? The big one, I probably should have put it first, but I didn't. But the big disadvantage is that more often than not, they are misused, okay? What do I mean by misused? I mean, either the wrong form is selected for the wrong project and the wrong parties. The parties mix and match the forms, right? Such that, they have, and we'll look at a specific example, a case that came out of North Carolina, and it's important because it's a great example of the monetary impact of having kind of inconsistent forms, if you will, okay? But a lot of times these forms are misused, and that can create problems for the parties down the road if they end up in a dispute. And then finally, interpretation problems. So, anybody who's been involved in a construction project understands and recognizes the fluidity that comes with it, right? The flexibility that you have to have because things come up, right? Maybe you come across some sort of, unknown condition in the ground, right? Maybe there's more rock in the ground. And so, the general contractor is now saying, well, what I originally bid for, removal of that rock is not enough to cover it because it's significantly more than anybody anticipated, right? Things come up on jobs. Building codes change that impact the design. And so you sometimes have to go back to the drawing board and revise that because of the building code change, right? Things come up. But what happens, unfortunately, sometimes on construction projects is in responding to situations, the parties reach an agreement that, so if you think about a party who has a standard form agreement, right, an agreement that has been prepared by an organization that is knowledgeable and experienced within the industry, that utilizes familiar terms and certain terms, right, and then the parties not following the same path, if you will, of the standard form contract reach an agreement after the fact, sometimes that agreement can create interpretation problems for the contract, right? Well, what was the party's intention? What is ultimately going to govern when a dispute arises between the parties, okay? And so, sometimes those after the fact agreements can cause problems, and that is one of the disadvantages to using standard form agreements. So with these in mind, okay, let's take a look at some examples. And one thing that I just want to start off and highlight, okay? So I know I told you no legalese. I do have a couple of case citations, okay, for you. And one of the things I just want to point out is, so I think the importance of reviewing and revising your standard form contracts. And to clarify, I think it is important to review and revise any contract, whether it is standard form or not, okay? So, but since we're just talking about standard form today, let's talk about those. And I think the importance is highlighted because in North Carolina and in practice, I'm not going to say every 50 states because I'm not licensed in other states, but North Carolina. But my understanding is every state is in a similar position, which is that courts impose a duty on parties to a contract to read that contract. Okay. And there is a presumption in North Carolina that a party to a contract has read his or her contract and has understood his or her contract. Okay. And absent some sort of fraud in the negotiation or execution of that contract, courts are not going to afford any sort of relief to a party who has breached the contract because the party did not read that contract. Okay. And a perfect example is the J.B. Colt versus Kimball case. It's a 1925 case from the North Carolina Supreme Court. And that was a case in which the court said, look, a party to a contract, in this case, the defendant, the breaching party, if you will, had a duty to read the contract or have it read to him. And his failure to do so in the absence of fraud is negligence for which the law affords no redress. And so the plaintiff, a judgment was entered in favor of the plaintiff in that case. Okay. So again, the importance is highlighted by the fact that if you don't read it, the court is going to assume you did. And it's telling the court if a dispute arises, well, I didn't read my contract. I didn't know that's what that said. Unfortunately, the court is going to assume you did, even if you didn't. Okay. So again, it's important to read it because you're required to read it. But let's talk about some examples within your contracts. Okay. So just to kind of clarify, this is not an exhaustive list. Okay. This is not an exhaustive review of a specific, standard form agreement or even a handful of standard form agreements, because I'll be honest, that would probably require more than one day and probably not be the most exciting thing for everybody who's here either in person or virtually, is to listen to me go line by line through a contract. But I do want to pull out some examples of standard form provisions that are either inconsistent or have resulted in potential problems, either specific cases or things that I have seen in my practice that highlight this importance of reviewing your contracts. Okay. So standard of care. I hope everybody here is at least familiar with the general idea of standard of care, right? This is what this is the standard a person is held to in the actions and inactions, that they may undertake, right? Whether it's, the standard of care of a doctor in treating his or her patient, the standard of care of a lawyer in providing legal advice, or the standard of care for a design professional such as engineers in performing engineering services. Okay. Now, so I have up here, I have an excerpt from the DBIA 535. Okay. That is the standard form of general conditions of contract between an owner and a design builder. Okay. I forgot to put the year up here. I'm pretty sure this was like 2015. And I can't remember if that's the current edition, but just to know that this is a couple of years old from this provision. There may have been some changes to it, but section 2.3.1 provides that the standard of care for all design professional services performed to execute the work shall be the care and skill ordinarily used by members of the design professional practicing under similar conditions at the same time and locality of the project. Now, I want you to just remember that last little bit of language, right? Under similar conditions at the same time and locality of the project. We go to the next slide. We have here an excerpt from the 2013 version of the EJCDC, which is your standard form agreement between an owner and an engineer for professional services. Okay. And section 6.01 states that the standard of care for all professional engineering and related services performed or furnished by an engineer under this agreement will be the care and skill ordinarily used by members of the subject profession practicing under similar circumstances at the same time and locality. So again, you get similar language in the EJCDC form, which is this, under similar circumstances at the same time and locality. However, North Carolina applies a slightly different standard for design professionals, architects, engineers, and land surveyors. So the seminal case in North Carolina is Associated Industry Contractors versus Fleming Engineering. It's a 2004 case from the North Carolina Court of Appeals. And in that case, the court, and in that case, the court talking about surveyors and civil engineers, but the standard also applies to all engineers and architects. The court said generally A surveyor or civil engineer is required to exercise that degree of care which a surveyor or civil engineer of ordinary skill and prudence would exercise under similar conditions. But notice what's missing. There's no express reference to same locality or same time as the project at hand. Now, some of you may be thinking to yourself, well, aren't those just, conditions, right? Aren't those conditions that would be considered? Maybe, right? The difference though is that under the contract provisions, the locality and time of the project are mandatory conditions. To the extent those are relevant to whether or not an engineer has complied with his or her standard of care in North Carolina are not mandatory, right? Certainly a party can offer evidence as to how other engineers would practice in the same locality at the same time, but the standard doesn't require it, right? It's under similar conditions, and it's gonna take into account various conditions, okay, in determining them. Now, I don't have the DBIA and EJCDC excerpt up there to suggest that those provisions imply a significantly higher degree of care upon an engineer than North Carolina. But it is an example of where you can get provisions in your standard form documents that are inconsistent with state-specific requirements, okay? And that is important because as design professionals, my hope is that everybody who's listening today and is present, my hope is that everybody has an E&O policy. If you don't have an E&O policy, or you don't know what an E&O policy is, maybe I'll do another presentation on insurance because they're very, very important. They're critical to our industry and they protect you, okay? However, depending on the terms of your E&O policy, which again can be a standard form agreement, it is possible that an architect or an engineer who contracts for and agrees to comply with a higher standard of care than that required by law could potentially face a denial of coverage under their E&O policies. So envision a situation where you sign a contract that says, I, the engineer, agree to perform my services to the highest degree of care, or with the highest qualities, right? Okay. That's a situation where I think that language could arguably, I'm not saying it is, but could at least arguably be higher than North Carolina's standard of care. Well, depending on the language of your policy, imagine you're facing a lawsuit of $5, $10, $15, $20 million. And now you're having to deal with potentially an E&O coverage denial on a policy that would cover you, but now because of the language of your contract might not cover you, okay? Fortunately, those kind of like, those sorts of phrases like the highest degree of care, right? As a baseline form, I think the likelihood that those show up in a standard form agreement are pretty minimal, right? You can go and see the base language of your standard form documents by pulling them up or paying for them and seeing them, right? But the problem though is if you're not the drafting party, if you're not the party who pulls it, the party who pulls it, they might make a change to it, right? And send it to you and revise the standard form language. And if you don't review it and you miss it and you sign it, well, now you've got a standard form document that's been revised to include a higher standard of care than required by law. And you're dealing with a situation, right, that we were just talking about, okay? So again, it is super important that you review your contracts and that you read them, that you understand them, and as necessary, revise them, okay? Let's talk about the statute of limitations, okay? So statute of limitations is another one of those things that lawyers have to obsess about, okay? And if you don't know what a statute of limitations is, okay, it is essentially the longest period of time that someone can wait before they have to file a lawsuit, before they potentially lose those rights, okay? Now, statute of limitations is different from a statute of repose. A statute of repose sets a substantive bar, right, where essentially the court says, well, regardless of whether or not your claim is arose, we're not going to let you bring your claim after a certain point. I'm talking about the statute of limitations, okay? Statute of limitations are triggered by some act or, and excuse the typo in there, but triggered by some act or event. In North Carolina, a breach of contract has a breach of contract claim has a statute of limitations of 3 years that typically runs from the date of breach, okay? When was the contract breach? Okay, negligence is also 3 years that runs from the date damage became apparent or should reasonably have become apparent, okay? I included both of those because while, if you have a contract, Generally, contract is going to govern, in North Carolina courts generally will not recognize a negligence claim, okay, a claim based in tort where the parties have a contract. There are situations in which, parties have been, particularly for design professionals, where they're facing both breach of contract and negligence claims, okay. And so while they're the same time period, 3 years, they run from 2 different dates. Sometimes those dates can line up, sometimes they don't, okay. But I want to talk with you about, so let's bring this back to standard form contracts, okay? And I'm mindful of my time. I've got about 4 minutes, so I'll see how much I can get through, but I'll at least finish this case because I do think this case is a great example. But so White Fox Construction Company versus Mountain Grove Baptist Church, okay, is a 2008 case from the North Carolina Court of Appeals. However, this case started in the 90s, okay? So back in is either 92 or 94, Mountain Grove Baptist Church was looking at expanding its sanctuary and building a gym. Every church has a gym nowadays, I feel, at least here in North Carolina. The church I grew up in had a gym, and the church down the road from me has a gym. Everybody's got a gym at their church. But Mountain Grove was looking to add a gym and expand their sanctuary. In 1994, White Fox submitted a bid on the sanctuary scope, okay? They submitted a bid for a guaranteed maximum price of $2.2 million. In 1996, so after they submitted the bid, Mountain Grove Baptist Church accepted their bid, and the parties entered into a contract in 1996, okay? Total cost for the sanctuary scope was $2.1 million, okay? The contract consisted of 2 parts. Part number 1 was the AIA A101 standard form of agreement between an owner and a contractor. It was on a lump sum basis, okay? And part number 2 was the AIA 191 owner designer builder agreement, okay? Now, A191 has since been replaced by the A141, which is still in use. A141 was drafted in 2004 and updated in 2014. But you had a contract in which you had 2 parts. You had a standard form of agreement between an owner and a contractor, which in my mind is not meant for a design build project. The case is not clear whether this project was built on a design build basis, but regardless, that contract is not a design build contract, okay? And then part number 2 was a design build type contract, okay? Fast forward to 1997, so work has started on the job. The parties execute a change order adding the gym scope for about $406,000, okay? During the approval and permitting process, the AHJ had required some changes to the original plans to comply with building codes, okay? And that resulted in added costs of about $817,000 due to these revisions, and these were added construction costs for the contractor. Fast forward a little bit more, in 2007, the contractor got into some trouble because it failed to pay several subcontractors on the job, which then resulted in lien claims on the church, forcing the church to pay off those subs directly. Okay, now they had the consent of the contractor to do it, but the church had to pay off those subs to free up its property. Okay, 4 years later, White Fox files a lawsuit against the church seeking about $1.1 million in damages plus interest and attorney's fees. Okay, so a pretty large lawsuit, right? Anybody's facing $1 million, that's a lot of money. In 2006, the trial court rules that the church breached the contract and awarded White Fox $865,000 in damages plus 18% interest and attorney's fees in the amount of $129,000. Okay, so the church is now on the hook. A judgment has been entered in by the trial court against the church in the amount of approximately $1 million. Okay, well, the church appeals. On appeal, the church argues that the trial court incorrectly concluded that White Fox had filed suit within the 3-year statute of limitations. Okay, now at this point, I'm sure you're wondering, Daniel, how does this have anything to do with standard form contracts? Well, at the trial court, at the trial court level, the court considered this: is the claim barred by the statute of limitations? And the court noted that in both parts, okay, both the A101 and the A191, both parts contain relevant provisions. Okay, so when you're trying to determine when a party breached a contract, you look to the terms of the contract, right? Because that's going to govern, right, what is a material breach and when does it occur? Okay. And then looking at the two relevant provisions, and so let me back up a little bit. So the claim by the contractor was that the church did not pay their final payment application. Okay, so they submitted their final payment application at the end of the job. Church didn't pay it, and they ultimately then filed suit. Okay, the court then looked at the contract provisions to say, okay, well, what does the contract say about final payment? Okay, both parts contain provisions on final payment, and the court concluded that the contractual provisions in the two different parts with regard to final payment were not in conflict and are not ambiguous. Okay, and the court concluded that so with respect to part number 2, which was the A191, so A191 provided that final payment was due upon the owner's receipt of the final payment application when the work had been completed and the contract fully performed. Okay, so focus on the upon receipt language. Part number 1, which was the A101, essentially provided for final payment within 30 days after issuance of the architect's certificate of final payment and the contractor's final payment application. Okay, so those are two different things, and the court is saying, well, we don't think that those are in conflict. We think they can be read together and they're not ambiguous. And as a result, the court concluded that what it means is it means final payment is required upon receipt of the architect's final application and certification for payment, but in any event, not later than 30 days. Okay, so the court read the two parts together to say there's no conflict between the provision. And as a result, the trigger for the statute of limitations was 30 days after the payment application was submitted. In this case, payment application was submitted on December 22nd, 2000. Court said, you add 30 days, the statute of limitations began running on January 21st, 2001. The contractor filed suit on January 16th, 2004, 5 days before the 3-year statute of limitations ran under the court's decision. On appeal, the court found that the trial court had overlooked a key provision within the party's contract. Okay, in part 2, okay, that's the A191 design build agreement. Section 11.10.1 provided that part 2, the A191, represents the entire agreement between the owner and design builder and supersedes part 1 and prior negotiations, representations, or agreements. Part 2 may be amended only by written agreement signed by both owner and design builder. Okay. And the court then said, and looking at that language, the court said, well, this clause unambiguously specifies that to the extent part 1 and part 2 of the contract contain provisions addressing the same issue, final payment, the provisions in part 2 supersede or override those in part 1. Remember, part 2 is upon receipt. Part 1 is within 30 days. Okay. If you're doing the math, you're probably starting to realize where this case is going. And here, I'm not going to read through this, but this is just the exact quoted language directly from those two provisions, right? Part 1, Article 6 being, again, not more than 30 days after the issuance of the final certificate of payment. Part 2 being upon receipt, upon the owner's receipt of the design builder's final application for payment. Okay. The court concluded that parts 1 and 2 both address final payment, but cannot be reconciled. In other words, you cannot have payment due upon receipt and within 30 days. It's either or is what the court said, okay? And as a result, they're in conflict. And under that section 11.10.2, the part 2, which was upon receipt, supersedes the 30-day payment provision. So let's look at how the math works out, right? So if payment is due within, if payment under the contract is due upon receipt, the final payment application was submitted on December 22nd, 2000. The court said the 3-year statute of limitations began running from that date, meaning the lawsuit had to be filed by December 22nd of 2003. The contract filed its lawsuit on January 16th of 2004, after the 3-year statute of limitations had run. And so as a result, the court ruled that the contractor's claims were barred by the statute of limitations. It reversed the trial court judgment, which again was just under $1 million plus interest, and ordered that judgment be favored in favor of the church. So in other words, the contractor went in the span of that appeal from a $1 million plus judgment to $0 and recovered nothing on a job where it had over $1 million in added costs. Okay. Again, it is important that you read your contract, that you understand what your contract is saying, and to the extent necessary, you revise your contract, whether it's to remove any conflicts in the terms, whether it's to reflect the intent of the parties, right? But you got to review your contract. If you don't review it, you're going to find yourself in a situation, the chances of being in a situation where you have a dispute and an unfavorable contract term are increased. Okay. The only other thing I just want to touch on, and then I'm going to finish up since we're a few minutes after 1, is indemnity and defense. Okay. Particularly for engineers, I think this is important to talk about. So when you look at the AIA C401 document, which is the standard form agreement between a architect and a design consultant, okay, or a consultant, there are a couple of provisions that deal with the obligation to indemnify. Okay. It's a mutual indemnification provision. So the consultant has to indemnify the architect and the architect has to indemnify the consultant. Okay. But the language here is that they have to indemnify and hold harmless from and against claims, or excuse me, from and against damages, losses, and other liabilities that arise from claims by third parties, including reasonable attorney's fees and expenses recoverable under law, but only to the extent they are caused by the negligent acts or omissions of the architect or the consultant in the performance of their respective professional services under the agreement. DBIA 535, which is the standard form of general conditions of contract for a design builder. And I bring this up because engineers and architects can be a design builder under the agreement, right? Well, 7.4.1 of 535 not only has indemnification language, but also includes defense language. So you'll see it says design builder to the fullest extent permitted by law shall indemnify, hold harmless, and defend owner. What does that mean by defend? Well, that means if, for example, if somebody files a lawsuit and the owner's got to go and, either you're going to hire the attorney for the owner, or you're going to reimburse the owner for their defense costs in defending that lawsuit. Okay. But it does have a defense provision within it. It's important because North Carolina last year, is either end of 2020, revised 22B-1, which deals with contracts against public policies. Okay. Well, Chapter 22B does. And in revising 22B-1, one of the things that they did was they added what a lot of us within the construction bar recognize as trigger language for indemnification provisions. Okay. Trigger language is language that has to be in your indemnification provision, lest you risk having that provision excluded because it's in violation of the statutory language. Okay. And that language, and I put it right here, so it says provisions in or in connection with a construction agreement or design professional agreement purporting to require a promisor to indemnify or hold harmless the promisee's independent contractors, agents, employees, indemnities, or any other person or entity against losses, damages, or expenses are against public policy, void and unenforceable, unless the fault of the promisor or its derivative parties is a proximate cause of the loss, damage, or expense indemnified. And I've highlighted that language because, the legislature has not come out and said, you have to have this language in your provisions. But when you talk to a construction lawyer, most construction lawyers are going to recommend that you have this language in here to minimize the chance that this provision is stricken. Okay. And that's important because courts in North Carolina, if you don't have the trigger language and a court says you have to have it, a court is not going to revise your indemnification provision to add it back in for you. Okay. What they're going to do is they're going to strike the whole thing. And so to the extent you had a valid basis for indemnification against your subconsultant, you could potentially be in a situation where you have these losses and you can't get indemnification from them because the provision has been stricken. Okay. On the defense side, the legislature in revising 22B-1 has just completely rendered any defense obligations void and unenforceable. Okay. You can't save the provision by having a trigger language in there. Okay. So if your goal, if you have a provision where you're wanting to seek your defense costs, or you want to have your consultant defend you, and your contract is entered into after the effective date of these revisions, well, then the defense provision is likely to be rendered void and unenforceable as a matter of public policy. Okay. So again, it's important to review your contracts. You got to read them, you got to understand them. And if necessary, you got to revise them to make sure that they work for you the parties involved, and the type of project, and the various other particulars of your project. So we're past 1 o'clock. I'm just gonna go ahead and stop, see if anybody has any questions. Anybody?
The only thing going on
Yeah.
right now is a lot of the inflationary pressures and the ability to collect, due to these added costs.
Mhm.
Any of these contracts better or worse than others with regards to the